Uh, I'll have the advocates all turn your cameras on at this time, please. Excellent. Ms. Bailiff, everybody is here. All the scoring judges are here, correct?
Yes, we are all set.
Thank you. Okay, well, with that, let's get started. We'll call the case of Marks v. Sonny's Rooftop Bar. My name is Judge Lovren. Scoring judges, thank you for having your audio and video off. Please continue to keep it off for the remainder of the trial. You should also have your video set to hide all non-video participants. If you haven't done that already, you can do that by going down to your stop video icon, clicking the small caret next to it, selecting video settings, and then clicking the checkbox to say hide non-video participants. This means that the only people on the screen right now should be the advocates and myself. Before we begin, advocates, I will let you know that I have read your complaint and answer, as well as Judge Pasquarello's pretrial order and the jury instructions. Can the attorneys please make appearances? We'll start with the plaintiff.
Yes, Your Honor. Good afternoon. My name is Sydney Gaskins, and I'm joined here today by my co-counsel, Mr. Thomas Kiley.
Good afternoon, Your Honor.
Today, we represent Miss Ethel Marks on behalf of her deceased daughter, Jessica Marks.
Thank you. Defense?
Yes. Good afternoon, Your Honor. My name's Audrey Shepard. Today, I'm joined by my second chair, Camille Schaefer.
Good afternoon, Your Honor.
Together, we represent the defendants in this case, Sonny's Rooftop Bar, Incorporated.
Thank you, defense. Are there any housekeeping matters before we proceed to opening statements?
Yes, Your Honor, we have a few. First, permission to invoke Rule 603, the constructive swearing in of all witnesses.
I assume there's no objection to that.
None, Your Honor.
Then we'll do so.
Also, Rule 615, which is the constructive sequestration of all witnesses, barring party representatives.
Defense?
That's fine with us, Your Honor.
We'll do so.
We do not have a party representative today.
Okay, and defense, are you being joined by a party representative?
Yes, Your Honor. Our party representative is going to be Sonny Mehta, an employee of Sonny's Rooftop Bar, Incorporated, pursuant to stipulation.
Okay, excellent. Any other housekeeping, plaintiff?
Yes, Your Honor. Finally, we'd like to draw your attention back to that pretrial order that you reviewed before today's trial. We want to talk about pretrial order number 11. Pretrial order 11 says that Exhibit 22 is pre-admitted and may be used at any time for any purpose. That's an autopsy report. And with that, we're ready for opening statements.
Thank you, plaintiff. Defense, any housekeeping matters?
Just one thing, Your Honor. We just like to make sure that the court took note of the stipulation, which states that all exhibits in this case have been pre-admitted for identification, just for the ease of trial today.
Yes. For anything that you'd like to enter onto the record before it has been entered for the first time, please just ask permission before showing it on your screen. We will do so constructively outside the view of the jury, but that way the scoring judges are able to see it as well. Once it has been admitted to evidence pursuant to the pretrial order, please feel free to show it on screen whenever you need it. Are we ready
Yes,
for
Your Honor.
opening statements?
Yes, Your Honor.
Okay, go ahead whenever you're ready.
May it please the court. The defendant ignored the obvious. On March 24th of 2019, a woman named Jessica Marks died. She was driving. Her car flipped over on the highway and into a ravine. She was only 19 years old. For the previous 3 hours, she was at the defendant's bar, Sonny's Rooftop Bar, where she was being served drink after drink after drink after drink. The defendant watched as Jessica Marks got drunker and drunker and drunker throughout the night. Her eyes became bloodshot. She started getting louder and louder. And she was stumbling. She's almost falling down the stairs, and the defendant, they do nothing. They don't cut her off. The defendant ignored the obvious. Jessica, she left the bar that night. She got behind the wheel. Just about a minute later, she was dead. That's why Jessica's mother has sued the defendant for wrongful death. Now, look, I want to make something pretty clear. We're not saying that drunk drivers bear no responsibility at all for their own behavior. They do. But in the state of California, the law requires bars and bartenders to be held responsible when they overserve people. That's why we're here today. As the plaintiff, we have a burden of proof. We have to prove to you 4 elements by a preponderance of the evidence, which means more likely than not to be true. Now, the first 2 elements on the screen, we've already agreed with opposing counsel on. We had to demonstrate that the defendant was licensed to sell alcohol. We also had to demonstrate that Jessica Marks was underage. She was 19. But those last 2 elements are the ones I want you to focus on throughout the course of today's trial. We have to prove to you that the defendant served alcohol to Jessica Marks while she was an obviously intoxicated minor. We have to then prove to you that the defendant serving Jessica Marks while she was obviously intoxicated was a substantial factor, whole or in part, to her death. That's exactly what we're going to do. And we're going to meet our burden by asking you to focus on 3 simple concepts: the drinking, the defendant, and the driving. So first, the drinking. Jessica's best friend, she's here today. And she's going to take the stand, look you in the eye, and tell you exactly what they were drinking that night and how it was affecting Jessica. She's going to show you a video that she took of how Jessica was acting that night. How Jessica said, "Go big or go home," and then struggled to find out which drink she should chug next. Next, we're going to talk about the defendant. We're going to show you that Sonny Mehta, the server and the owner of that rooftop bar, just kept giving them drinks and knew they were getting intoxicated. You're going to hear that the owner of that bar ignored the fake IDs, was careless from the very beginning, and even said, "We might need to cut this one off," but never did. Last, we're going to focus on the driving. We're going to talk about how the defendant watched Jessica leave that bar that night, go out to her car, and then just moments later, Jessica died. And that's why at the end of today's trial, when I speak to you again, I'm going to ask you to come to the only conclusion that you can, that the evidence supports and the law requires. We're going to ask you to find the defendant liable for wrongful death. Thank you.
Thank you, plaintiff. Defense, whenever you're ready.
Yes, Your Honor.
Go ahead.
She carried the keys. Members of the jury, you just heard a lot about what happened inside of a bar 2 years ago. But today you're going to hear that the deadliest decision in this case didn't happen in that bar. It happened hours earlier. Let's go back. Back to 8 p.m. on March 24th of 2019. It's the last day of spring break, and Jessica Marks wants to have one last night of fun with her best friend. So they decide to go drinking. Ms. Marks has decided that she's going to drive that night. Not as the designated driver, no, because she decides that she's going to be just fine to drink and drive. But her plan wasn't safe. And she paid the ultimate price. She carried the keys, and it killed her. Now, members of the jury, before we get into any further, I want to make something very clear. We agree that Jessica Marks's death is a tragedy. And any discussion of mistakes that were made that night won't make it any less so. She was 19. She just started college. She had her whole life ahead of her. But today, you are here to determine who was responsible for her death. So let's talk about what the law tells us regarding responsibility. You see, today the plaintiff brought a claim, and so they bear a burden. They have to prove their case by a preponderance of the evidence. They have to show you that they knew, the employees at Sonny's bar knew, that Ms. Marks was showing signs of obvious intoxication, that they knew that and still continued to serve her, and that as a result, she died. Today, the evidence won't support the plaintiff's allegations because they simply won't be able to prove that they knew, and as a result, she died. Now, that's not going to be the only reason that you're not going to be able to find Sonny's bar responsible, because today we've brought something called an affirmative defense of comparative fault. That means that you're going to have to ask yourself another question. You're going to have to ask yourself, more likely than not, did Ms. Marks's decisions cause her death? And with the evidence today, we are going to prove that to you. More likely than not, because she carried the keys, she made 3 careless decisions. Let's talk about those decisions. Decision number 1, she drove. You're going to hear how Ms. Marks's first dangerous decision that night was to choose to drive her car to the bar with the intention of drinking. Which brings us to decision number 2. After arriving at the bar that night with the keys in her pocket, Ms. Marks drank. Not just one drink, not just 2, but drink after drink, round after round, from wine to shots to hard seltzers. Which brings us to the final and most heartbreaking decision that she made that night, decision number 3. Because you're going to hear that though she was given other options, Ms. Marks chose to drive again. Today, you'll learn from Ms. Marks' best friend. She's going to testify today, members of the jury, that the Uber was there, that she begged her friend to take it, but you're going to hear that Ms. Marks had already made up her mind. She had those keys in her pocket, and she decided to follow through on her plan. The evidence will show that instead of getting in that Uber, Ms. Marks drove home. Members of the jury, at the end of this trial, the evidence is going to be clear. Ms. Marks carried the keys, and it cost her her life. When she picked up those keys, members of the jury, she picked up the responsibility to act with reasonable care for her own safety and the safety of the others on the road. But her decisions weren't reasonable. Her decisions were negligent, and they caused her death. That's why at the end of this trial, we're going to ask you to find Sonny's bar not liable for the death of Jessica Marks. Thank you.
Thank you, counsel. Plaintiff, are you ready to call your first witness?
Yes, Your Honor. At this point, we call Morgan Levin to the stand.
Okay. At this time, I will ask everyone to switch to gallery view. That button's in the upper right corner of your screen. Click on the tab that says view and then select gallery. That way you'll be able to see myself, the attorney, and the witness at the same time. I will leave my video on, but mute myself. If I forget, please let me know that you can't hear me. And I will try to speak loudly in case my AC turns on. Ms. Levin, you've been constructively sworn in. And Attorney Gaskins, whenever you are ready to proceed.
Good afternoon. Could you please introduce yourself to the members of the jury? Oh, Ms. Levin, you're muted. Go ahead, turn it on.
Sorry, can you hear me now?
Yes, I can hear you. Could you please introduce yourself to the members of the jury?
Good afternoon. My name's Morgan Levin.
And what do you do for a living, Ms. Levin?
Well, I'm actually a student. I just finished my junior year at UCLA.
What do you study?
My major is biology. I'm pre-med. I want to be a doctor.
How did you get involved in this case?
Well, I'm Jessica Marks's best friend. We were together on March 24th of 2019.
What were you doing with her on March 24th of 2019?
She was up visiting me at UCLA for spring break. So we were together that night. We decided to go out to a bar in Los Angeles called Sunny's Rooftop Bar.
Would you recognize a map of the area around Sunny's Rooftop Bar if I were to show it to you today?
Yes, I would.
Your Honor, do I have permission to screen share what's been pre-marked for identification as Exhibit 20?
Yes, at this time you can share it constructively outside the view of the jury.
Do you recognize what I placed on the screen?
Yes, ma'am, I do. That's a map of the area we were on March 24th.
Is it a fair and accurate depiction?
It is.
Plaintiff offers Exhibit 20 into evidence.
Any objections? Okay, so admitted.
Permission to publish?
Yes.
Ms. Levin, where on this map is Sunny's Rooftop Bar?
It's that building right there on the left side of the picture with the purple marker.
Thank you, Mr. Kiley. You can take that down. We'll come back to it in a moment. The first thing I want to talk about with you is the drinking that happened at the bar. When did you and Jessica arrive at Sunny's?
We first got there right at 9 p.m. We went up to the roof and we started ordering drinks then.
How old were you both at the time?
We were 19. We used fake IDs to get in.
How much did the two of you have to drink?
I had a glass of red wine and a beer, but Jessica had a lot more than that.
Would you recognize the bar tab from that night if I were to show it to you today?
Yes, ma'am, I would.
Your Honor, do I have permission to screen share what's been pre-marked as Exhibit 17?
Yes.
Ms. Levin, do you recognize what I've placed on the screen?
I do. That looks like my receipt from that night. I ordered drinks for Jessica and I.
Is it a fair and accurate copy?
It is, yes.
Plaintiff offers Exhibit 17 into evidence.
Any objections?
No, Your Honor.
It is admitted.
So Ms. Levin, let's break down the drinks on the screen. From this list, what did Jessica have to drink?
Well, she had red wine that night. She had 3 White Claws. They're hard seltzers. She had a beer, and then she also had shots.
Were those 4 things on the screen the only things that you saw Jessica have to drink?
No, ma'am. She also had a mixed drink that night as well that we didn't pay for.
Objection, Your Honor. Lack of foundation as to how this witness knows that the other beverage was a mixed drink.
May I respond?
Yes.
This witness was with Jessica this entire night. She saw Jessica order that mixed drink and then drink it.
Why don't you lay some foundation and have the witness testify as to that, and we can revisit the objection.
Yes, Your Honor. Miss Levin, how do you know that Jessica ordered a mixed drink?
I saw her order it that night at some point that evening. It just wasn't on our receipt. I didn't pay for that one.
After permission to publish this to the members of the jury?
Yes.
Thank you. You can take that down, Mr. Kiley. After you saw Jessica have multiple drinks, did you notice her behavior change?
I did, yeah. I saw that her eyes started to get a little more red. Her words were slurred, her speech, she wasn't speaking normally anymore as she started talking really loud. She even started stumbling around the bar that night.
Did you notice anything about her eyes?
Yeah, they started to turn red too. And I mean, her breath even smelled like alcohol.
Did you happen to record how Jessica was acting that night?
Yes, I did. I have a video of her.
Permission to put on the screen what's been pre-marked for identification as Exhibit 10.
Yes, once again, constructively outside the jury's view.
Do you recognize this video?
Yeah, that looks to be the first frame of the video I took.
Does this look like the same video that you took of Jessica that night?
It does.
At this point, plaintiff offers Exhibit 10 into evidence.
No objection, Your Honor.
Okay, it is admitted.
Mr. Kiley, could you go ahead and play that video?
Hi everyone, Morgan and I are in Hollywood. We're at a bar. It's kind of like a Philly bar, except everything is really, really expensive. $10 for a seltzer. And everyone here wants to be a model or an actress. You know, I'd like to thank the Academy. Mom and Dad, you've inspired me. Okay, well, go big or go home.
From your perspective, Miss Levin, what did we just watch?
That's how Jess was acting that night at the bar.
Permission to publish that video to the members of the jury?
You may do so.
Thank you, Mr. Kiley. You can go ahead and take that down. Now I want to talk about the defendant. Do you know Sunny Mehta?
Yeah, I know Sunny Mehta owned the bar we went to, and I also know he was our waiter that night.
A moment ago, you mentioned that Jessica was stumbling. Do you know if the defendant ever saw Jessica stumble?
Saw her. She fell into him.
What happened next?
Well, he said, hey, maybe we should cut this one off.
After Sunny Mehta said, maybe we should cut this one off, did he say anything else?
Yeah, he said, I hope this one's not driving home.
Did anyone from Sunny's bar ever cut Jessica off?
No, we drank for the next hour and 45 minutes after that.
Miss Levin, now I want to talk about how Jessica drove home, the driving. When did you all leave the bar?
We left at around 11:45 that night.
What happened after the two of you left?
That's when Jess got in her car. I had called for an Uber. You know, I asked her to take it with me. I told her I'd pay for it. But she drove. She got in her car.
What did you see after Jessica got into her car?
Well, she pulled out of the parking lot, and there was this highway we had to take to get back to where her Airbnb was. So we started down that road. I was right behind her. And she was driving fine at first. But then the car, I saw it take a swerve to the left really fast. It went over the median, and that's when I saw it go over the side of the interstate.
If I showed you that map again, would you be able to show the members of the jury where that crash happened?
Yeah, I could.
Permission to put back up on the screen that map.
Yes, go ahead.
Miss Levin, where did that crash happen?
It's right there at that yellow marker, just right out of the parking lot.
How far did Jessica drive before she crashed?
We just got like a minute down the road. I mean, it was like 1,000 feet or something.
I think you can take that down. What happened to Jessica after the crash?
That's when the paramedics came. Her car, it had flipped upside down. They told me when they got there that she had died. I lost my best friend.
Thank you, Miss Levin. Your Honor, I have nothing further.
Cross-examination.
Yes, Your Honor. Good afternoon, Ms. Levin.
Good afternoon.
Before we get into things, ma'am, I just want to say I'm really sorry for your loss. I'm just going to ask you a quick couple of yes or no questions. We'll make sure to get you out of here real fast, okay?
Okay.
Ma'am, I actually want to take a moment to take a look back at that map you were showing us on direct examination. I want us to take a step back to talk about where that night actually began. Ma'am, you were with Ms. Marks the night at the bar, right?
Yeah, I was with her.
Your Honor, we're now displaying that map that was shown previously. Ma'am, you actually recognize this as Exhibit 19, right?
Yeah, I do. Mm-hmm.
And you recognize Exhibit 19 as a map of West Los Angeles?
It is, yes.
Now, you can see here on Exhibit 19 that there are a few markers on this map indicating location.
Objection, Your Honor. This document is not in evidence.
May I be heard?
Yes, counsel.
Your Honor, I'm laying foundation to enter this into evidence.
Okay, well, we'll keep this outside the view of the jury for now.
Ma'am, you see some markers on this map indicating locations that you and Ms. Marks went on March 24th, right?
Yes, I do.
It looks to be a fair and accurate copy of a map.
It is, yeah.
Your Honor, defense requests to move Exhibit 19 into evidence.
Any objection?
No objection, Your Honor.
Okay, so admitted, you may publish now.
Yes, Your Honor. Ma'am, let's zoom in. Because the night that you were with her on March 24th, you and Ms. Marks spent some time at her Airbnb, right?
Yeah, that's right. That's where she was staying while she was visiting me.
Her Airbnb was in Brentwood?
Yeah, it was.
Her Airbnb is indicated with a blue marker on this map.
It looks to be, yeah.
Now, you also spent some time at Sonny's bar that night, right?
Yes, that's right.
Sonny's bar is in Malibu.
That's right. Yeah, it's that purple marker there.
Ma'am, the purple marker on this map you're saying indicates where Sonny's bar was, where you went.
Right, yes.
So for the members of the jury, ma'am, you and Ms. Marks went from Brentwood that night all of the way to Malibu?
Yeah, that's right.
Well, then I want to talk about the decisions that were made once you arrived at that bar in Malibu. Now, ma'am, you actually got first to the Airbnb around 7 or 8?
Yes, I did.
At the Airbnb, you and Ms. Marks had some wine together.
Yeah, she had a glass. I had one too.
You remember her having 1 or 2 glasses, actually?
Yeah, just some glasses of wine.
And around 8:30, you two left the Airbnb.
That's right, for Sonny's bar.
But Ms. Marks, she didn't call up a cab to take you to Sonny's bar, right?
Right, at that point, she looked fine to me. She was fine to drive that night.
Well, ma'am, I'm not asking you whether or not she was fine to drive. I'm asking you what she decided to do. And she didn't call up a cab to take you two to Sonny's bar, right?
Right, at that point, she just drove.
She didn't order an Uber.
Right.
You just told us that she actually took her keys and turned on the ignition that night.
Yeah, she did on the way there. Mm-hmm.
She drove to Sunny's bar.
She did.
Ma'am, she was behind the wheel as you two headed to go get some drinks.
That's right.
With that in mind, let's talk about what actually happened when you two arrived at Sunny's bar. You got there around 9 p.m.?
Yes, we did.
And when you got inside the bar, you two had some drinks, right?
We did.
And you had quite a few.
I wouldn't say quite a few. I had some drinks at the bar, though. Yeah.
Well, ma'am, on direct examination, you told us that you had wine and beer, right?
That's right.
You also had some shots that you didn't mention.
I had one shot, yes.
Ms. Marks was also drinking that night, right?
She was.
And after drinking, you two left around 11:45.
That's right.
Ma'am, at 11:45, you called an Uber.
I did, yeah.
You called an Uber because you were concerned that Ms. Marks was not safe to drive.
Yeah, she wasn't acting at that bar like she could drive home. You're right.
You told Ms. Marks that you were concerned she wouldn't be able to drive.
Yeah, watching how she was acting that night, I didn't think she should.
You begged her to take the Uber?
Yeah, I did.
Ma'am, on direct examination, you told her that you would pay for the Uber, right?
Yeah, I wanted her to ride with me.
But she didn't.
No.
She told you she was fine?
Yeah, she did.
Ma'am, when you got in that Uber, Jessica Marks took out her keys.
Yeah, she did.
You heard her turn on the ignition.
No, it happened faster than that.
Ma'am, you saw her drive out of that parking lot.
Yeah, I followed behind her.
Ms. Levin, you know, and she died on her drive home.
Of course I know that.
Thank you for your time, ma'am. I appreciate you answering my questions. No further questions, Your Honor.
Thank you, counsel. Redirect?
No redirect, Your Honor. Can Ms.
Okay.
Levin step down?
Yes, thank you, Ms. Levin. I believe that's it for the plaintiff's witnesses.
Yes, Your Honor. At this point, we rest our case in chief.
Okay, defense, go ahead and call your witness.
Yes, Your Honor. Defense calls Sunny Mehta.
Mr. Mehta, you are under oath. Attorney Shepard, go ahead and proceed when ready.
Yes, Your Honor. Good afternoon, sir. Could you please introduce yourself to the members of the jury?
Good afternoon. My name is Sunny Mehta, but call me Sunny, please.
Well, Sunny, what do you do for a living?
Right now, not much. I'm looking for the next thing. I used to own Sunny's rooftop bar over in Eastern Malibu, but lost the bar about a year back.
Well, sir, do you know why you're here today?
Yeah, I know why I'm here. A young lady passed away a couple of years back, and she was at my bar that night. And you know, ma'am, I want to say something here. I know your lawyers are doing your thing, but they told me that Jessica's mother is on this call. And I just wanted to say that, ma'am, I am so sorry for your loss. And Ms. Shepard, that's why I'm here tonight. I'm here to tell you anything that I remember from that night.
Well, sir, did you know Ms. Marks that night before she arrived that night?
No.
Well, I want to talk about what training you have, if any. Sir, do you know if there are any signs to look for to indicate that someone's had a little too much to drink?
Well, yes, ma'am. I mean, to be a bar owner in California, you got to take some tests, pass some training, and you have to be able to identify those signs. So yes, ma'am, I can do that.
Well, can you tell the members of the jury some of those signs?
Sure. I guess you would look for red or watery eyes, vacant gaze, maybe flushed cheeks. You would listen for slurred speech, loss of balance, things like that.
Well, with that in mind, sir, I want to talk back to Ms. Marks. Sir, you told us that she was at your bar. Do you know what date that was?
Yes, ma'am. It was March 24th, 2019.
Do you remember what time she arrived at your bar?
Yes, she and a friend arrived around 9 p.m. that night.
And when she arrived around 9 p.m., did you see any of those signs that you were mentioning about earlier?
No, no, ma'am.
Well, what did they do when they arrived?
I mean, pretty standard. She and her friend Morgan, they came in and we brought them up to the rooftop, Sonny's rooftop bar. That's our best spot. Went up there and they started ordering drinks, same as anybody else.
Well, so you're saying that they were ordering drinks. Do you know who their server was that night?
Yes, that was a Sunday night, pretty slow. There was only two of us there, and I was the server for everybody. So I served those two.
Well, do you remember how many rounds they ordered that night?
Yeah, I mean, they both ordered about 4 to 5 rounds, maybe.
So how many times do you remember going to their table that night?
Well, I went there to get the orders and then to give them the drink. So 8 to 10, I guess. That's the best I could say.
Mr. Mehta, during those 8 to 10 times that you were going to their table, did you ever see signs that Ms. Marks had too much to drink?
No.
Well, sir, I want to address something that was talked about earlier. Were you present earlier in trial today?
Yes, ma'am. I've been here the whole time.
Your Honor, permission to display what's already been admitted as Exhibit 10?
Yeah, go ahead.
And Your Honor, may we publish this to the jury at the same time?
Yes.
Now, Mr. Mehta, do you recognize the image that's up here on the screen?
Yeah, it looks like that's from that video that you all showed a couple minutes ago, maybe.
Sir, I've got to ask. What you saw in this video, is that how you remember hearing Ms. Marks' sound on March 24th?
Oh, no, ma'am.
In this video, is this how you remember seeing Ms. Marks acting on March 24th?
Oh.
Well, we've talked about how she was acting when she arrived. We've talked about how she was acting when you were bringing her drinks. I want to turn our attention to the end of that night. Around what time did she leave?
She left probably about 11:45, maybe 11:50 that night with a friend.
Where were you when they left?
I was downstairs. So the rooftop is obviously above. Me and the bartender were downstairs behind the bar, and her friend came down with her and they checked out and left.
Sir, when they checked out and left, did they come down a pair of stairs?
Well, yes, like I said, the stairs are actually right across from the bar, and watched them come down and they would have been right in front of us. That's right.
Mr. Mehta, do you usually watch your customers come down the stairs when they leave?
I mean, yeah. It's kind of our last chance to see them as they're getting ready to leave. So we always keep an eye on them to make sure that they're all right.
Well, why would that be helpful for you?
Well, I mean, we don't want anybody walking out if there's nobody in the party that, is competent. And so we try to make sure that at least somebody there is, looking sober at least.
Well, when you saw them coming down those stairs, did you notice Ms. Marks stumbling down them?
No, I mean, her friend was a little stumbly, but Jessica seemed fine.
Well, you're saying her friend was stumbly. Did you say anything about that?
Well, yeah, I mean, frankly, it was the friend that I was a little concerned about. She was a little stumbly, her eyes were bloodshot. So I went over and I said, hey, is this one driving home tonight?
What did Ms. Marks say?
She told me absolutely not. She said, no, I'll drive.
Sir, when she told you that she was going to drive, at that point, did you see any signs that she had too much to drink?
No, I mean, I was talking right to her, like you and I are now, but without the computer. And she seemed fine.
Mr. Mehta, I want to make something clear for the members of the jury. If you had seen those signs, what would you have done?
I mean, I would have kept checking up on her, and I would have probably started by bringing her a couple of glasses of water.
And when she was leaving, if you'd noticed those signs, what would you have done?
Oh, if she was leaving and I noticed those signs, I would have taken her keys.
Have you ever done that to a customer before?
Absolutely. I mean, maybe once a week we have somebody like that. And I'm not afraid to say, you got to get a taxi.
Sir, you told us earlier that Ms. Marks told you that she'd be driving home that night. When she was walking out that door at 11:45, did you hear her call a cab instead?
No, not that I can remember.
Did you see her order an Uber?
No.
When she walked out that door at 11:45, did she tell you that she was going to change her plan to drive herself home that night?
No, she never said anything like that.
Thank you. No further questions.
Cross-examination?
Yes, Your Honor. Mr. Mehta, I want to start by talking about the underage drinking that was happening at your bar on March 24th, okay?
All right, and please do call me Sonny. I'm really more comfortable with that. But yes, absolutely.
Okay, Sonny, you're sure that you ID'd everybody under the age of 45 on March 24th, right?
Objection, Your Honor, confuses the issues under 403. May I explain?
Go ahead.
Your Honor, pursuant to jury instruction 11, whether or not Mr. Mehta knew that Ms. Marks was underage is not at issue in this trial. Now, for Ms. Gaskins to ask questions about whether or not he was carding people, whether or not he did that successfully, that confuses the issues, and therefore it's inadmissible under 403.
May I respond to that?
Yes.
We're absolutely not confusing the issues because, like Your Honor read, the complaint and the answer, they are disputing whether or not they served an intoxicated minor. So it's certainly probative for us to ask this witness about the fake ID that she used. And if I may make an offer of proof.
Go ahead.
We're going to establish that this defendant knew that that ID was fake and still served Jessica anyway. So this is certainly an issue in today's case because it goes straight to our third element.
May I be heard?
Yes.
Your Honor, both parties have stipulated that Ms. Marks was a minor that night. Pursuant to jury instruction 11, Your Honor, and if we may display that for your convenience.
Sure.
Your Honor, jury instruction 11 states, to be liable, the defendant need not have known Ms. Marks was a minor. Now, Your Honor, to go into this line of questioning, which, as Ms. Gaskins just told us, is with the intention to show that she didn't know and ignored their fake IDs, well, Your Honor, that confuses the issues, and that's inadmissible under 403.
May I respond to that?
Yes.
I would like to have my tech chair share the complaint and the answer so we can refer to that now.
Okay.
Right there, it states, on March 24th, 2019, Jessica Marks was younger than 21 years old. That's what we agree on. Number 6 in the answer says that defendant, lacking information and belief, denies this allegation. So members of the jury need to hear us probe this witness about this because it goes straight to the issues that they denied in their answer.
Your Honor, may I be heard?
Just a second. Attorney Gaskins, doesn't the pretrial order stipulate that both parties agree as to Jessica Marks' date of birth?
Absolutely, Your Honor, but that's not what we're talking about here. Even though both parties agree that she was under 21 years old, that doesn't mean that they agreed that the defendant knew that she was under 21 years old and still served her. And that's certainly probative because they denied that in their answer.
May I respond to that argument, Your Honor?
Just a minute. Attorney Gaskins, why does it matter whether or not they knew she was under 21 when they served her, when the law says that their knowledge doesn't matter?
The law doesn't say that their knowledge doesn't matter. It just says that we need not display that, but we can display it for other reasons, like to show the carelessness of the defendant. May I make another offer of proof?
Yes.
Our whole case is about how the defendant ignored the obvious, and that goes straight to what we're trying to do here, because this defendant ignored the fact that they were 21, served them anyway, and then served them a large quantity of alcohol. So this goes right back to the carelessness of the defendant that's at issue in today's case.
Would you like to respond to that, Attorney Shepard?
Yes, Your Honor. Your Honor, if they're using this to show carelessness, at that point, we're coming into an issue of character evidence showing conformity. Your Honor, the jury instructions is the judge's explanation, as you know, of the pretrial orders, complaints, and answers. The judge explicitly states that whether or not they knew that she was a minor is not at issue today. Now, for Attorney Gaskins to continue to ask this witness about what he did and did not know about her being a minor has no probative value. And the prejudicial effect, Your Honor, well, it actually goes along with prejudicing the members of the jury to believe the story she's telling. But it being consistent with her story, Your Honor, that doesn't make it admissible in trial today. And so since jury instruction 11 tells us it's not probative, this is inadmissible under 403.
May I respond to that, Your Honor?
Yes, briefly.
There are a couple issues with what Ms. Shepard is saying. First, she's not talking about how we put the complaint and answer up on the screen, which proved to you that the defendant knowing whether or not she was a minor was something that they denied. And then in opening statements, I showed you that elements demo, and we have to display that the defendant served an obviously intoxicated minor. And to that 404 argument that she was making a moment ago, this is absolutely not improper character evidence because we're not offering this for propensity purposes. And that's what Rule 404 requires. This all happened during the same night. This is March 24th. We're not offering this to display that because it was careless on one occasion, he was careless on another. This was the same occasion. And even if Your Honor were to think that it is character evidence, there are permitted uses of character evidence, including displaying the knowledge of the defendant, which is exactly what we're doing.
Your Honor, may I make a distinction here?
Very briefly.
Your Honor, carelessness in checking IDs is not carelessness in seeing or ignoring signs of intoxication. Those are separate instances. And the jury instructions tell us that checking IDs isn't probative. It tells us knowledge of signs of intoxication is probative. And because there's a distinction, bringing this up in trial confuses the issues for the members of the jury. Your Honor, we have to trust the jury instructions here, and it states that it's not probative. So it's not admissible under 403.
Your Honor, may I respond to that?
No, I'm going to make my ruling. We have a little bit of a contention here because the pretrial order says we can also not amend the pleadings at trial. So I am going to allow the line of questioning on a very limited basis to establish whether or not she was underage, since you do need to prove that factor. But if you believe it goes too far, defense, you may re-raise your objection.
Yes, Your Honor.
You're sure that you served everybody who looked under the age of 45 on March 24th, correct?
That I served everybody? I'm not sure what you're asking.
Sir, that you carded everybody who looked under 45 years old, right?
That I carded everybody? That's my policy, ma'am. If somebody looks like they're under 45, I ask for their ID.
Right, so it was your policy that night to ask Jessica Marks for her ID, correct?
Yes, ma'am, I'm sure I did. I'm sure of it.
You are sure that you were showed an ID in your deposition as well, right?
Yes, ma'am. When they were prepping me for this trial, I saw an ID. That's right.
You know that was Jessica Marks's ID now, don't you?
That's what they told me. Yes, ma'am.
After you saw that ID in your deposition, you knew it was an obvious fake ID, right?
Yes.
Objection, Your Honor. I'd like to re-raise my previous objection on the grounds of 403. This is now going into his knowledge or lack thereof, not whether or not she was actually a minor at the time of her death.
May I respond to that?
Yes.
What Ms. Shepard just said in her argument is that it doesn't go to the witness's knowledge, but my question was, you knew. I'm going exactly into the witness's knowledge about how old Jessica Marks was.
Your Honor, knowledge is what I'm objecting to.
Attorney Gaskin, why is it relevant that he knew that she was under 21?
Your Honor, can I respond to the 403 objection?
Was that the objection, Attorney Shepard?
Yes, Your Honor.
Sorry. Yes, go ahead, please.
Under Rule 403, it has to be substantially more unfairly prejudicial than probative, and in this case, confusing the issues of the trial. And it doesn't meet that high burden because we're just displaying that this witness knew about the age when in fact the defense is denying that this witness knew about the age. This goes to the credibility of this defendant. This goes to the carelessness of this defendant. And she made a distinction a moment ago in the other objection battle saying that IDs and drinking are two different things, but members of the jury, Your Honor, excuse me, they're not. They're closely related. And that's what I'm just trying to get at.
Response, Attorney Shepard?
Your Honor, two things. Responding to the argument that knowledge is probative, and so the substantial effect doesn't outweigh it. Your Honor, if there's no probative value, the substantially misleading issue here is going to make it inadmissible under 403. Now, she's saying that the probative value here is his carelessness. Your Honor, that's not admissible. That leads us to be talking about character evidence. That raises a whole other issue.
Your Honor, I already argued the character evidence objection.
Okay,
I said it wasn't character evidence.
Hang on a second. Attorney Shepard, what about her credibility argument?
Your Honor, it's our contention that this doesn't go to his credibility or lack thereof for truthfulness on the stand today. Whether or not he was able to identify an ID as a fake or not during his deposition, but not at the night in question, that's not an issue of truthfulness or untruthfulness, and therefore it's not an issue of credibility. And once again, Your Honor, because it's not an issue of credibility, or at the very least a very small one, the prejudicial effect here substantially outweighs any little probative value. And so it's inadmissible under 403.
Attorney Gaskins, last response.
Your Honor, back to Rule 403. They have to demonstrate that this is substantially unfairly misleading the jury, confusing the issues in today's case, but it's not, because we're talking about the defendant's knowledge. That is the most probative thing in this entire case. What the defendant knew from the moment that Jessica Marks walked into the bar to the moment that she left. So it's certainly probative to go after what they're claiming, that this witness did not know that she was under 21 by me asking this witness, you surely knew that she was under 21. We're attacking what they claimed when they came to court today. And this is completely different from the pretrial order, the stipulation where we agreed that she was 19 years old. This is about the defendant's knowledge that they talked about in the answer.
I'm going to sustain the objection.
Mr. Mehta, I want to talk about the drinks that you served Jessica that night. You would recognize the bar tab if I were to show it to you today?
Yes, ma'am, I would.
Your Honor, permission to put back on the screen what's already in evidence is Exhibit 17?
Yes.
Jessica was at your bar from about 9 to 12 or so, right?
That's right.
So let's go through what you served Jessica's table. You served her an entire bottle of wine, right?
That's right. Table 4 got a bottle of wine.
You also served that table White Claws, true?
Yes, ma'am. That's right.
You served them 2 beers, correct?
Yes, ma'am.
You also served 2 shots, right?
That's right. Yes, ma'am.
You saw them take those green tea shots, didn't you?
I didn't see them personally drink it, but I assume they did. Yes.
And you said on direct examination that you must have went to their table between 8 and 10 different times, right?
Yes, ma'am.
So let's talk about what you knew about Jessica when you were at that table. You thought that she was around 5 feet tall, right?
From what I could see, I thought about 5 feet. That's right.
She looked like a small woman to you, correct?
To me, yes, ma'am.
You knew how dangerous it could be to serve someone who is underage, right?
Absolutely. Yes, ma'am.
You mentioned on direct examination that you're trained to watch to see if people become obviously intoxicated, right?
That's right. We know the signs to look for, and I check all my customers over to make sure that they're not exhibiting those signs.
Well, we'll get back to that in a moment. But first, I want to ask you, you claim that you thought Jessica was perfectly sober after going to her table 8 to 10 times?
She seemed totally sober to me, ma'am. Absolutely.
So that's your testimony today, that for the entire 2 hours that Jessica was at that table, she seemed perfectly sober?
She seemed fine to me.
You said that Jessica ordered at least 4 of what was on that bar tab, right?
Probably. They both ordered each time, so probably about 4. That's right.
So after you served 4 drinks to Jessica, you didn't notice any change in her behavior?
No, and ma'am, that's exactly what we look for is change in behavior. Everybody handles their drinks differently. I didn't notice a change.
So let's talk more about what Jessica's behavior actually looked like. You would recognize a video of Jessica if I were to show it to you today.
I would think so.
I'm putting back on the screen what's already in evidence as Exhibit 10. You recognize this as the video that you were shown in your deposition, right?
Yes, ma'am, I do.
You watched the entire thing, didn't you?
Yes, it's about a minute long, I think.
You recognize the setting to be your bar, right?
Yes, ma'am.
You recognize the woman in this video to be Jessica, correct?
That was Jessica. Yes, ma'am.
I want to talk about your thoughts about this video.
Okay.
After you watched this video, you thought it was possible that Jessica was intoxicated in this video, right?
I would think that somebody like this might be if I saw it. Yes.
So let me pick up on that. You think after watching that video that somebody who behaved like Jessica might be intoxicated, right?
Yes, I would start to check up on them, give them some water, and start to monitor that situation.
So let me follow up on that. If you saw somebody behaving like Jessica was in that video, you would feel the need to get them some water, right?
Like I said, really just the need to kind of start looking out a little bit more. I use the water as an excuse, but yes, ma'am.
You use the water as an excuse?
To start looking up at them a little bit more and monitoring them. Yeah.
Right, Mr. Mehta. So if you saw somebody acting like Jessica was acting in that video, you would feel the need to check up on them, right?
That's what I said, ma'am. If I saw somebody acting like that, I would check up on them more.
So I want to use your words again. If you saw somebody acting like Jessica was in that video, you would be concerned, right?
I might start to get a little concerned. I wouldn't be really concerned until they got worse, but I might start to get a little. That's true.
Well, sir, I'm not asking you if you would start to get a little concerned. I'm asking you if you saw somebody acting like Jessica was acting in that video, you would be concerned. Those were the words you used in your deposition. Isn't that right?
If I remember correctly, I said I might be a little. That's right.
Jessica was acting that way on March 24th of 2019, right?
No, not that I could see.
You saw that video, right?
I saw that video, ma'am, but I also saw Jessica that whole night. From what I could see, no.
Sir, I'm just asking about the video. You know that the video was taken on March 24th of 2019, right?
That's my understanding. Yes, ma'am.
Your understanding is that that video was taken the same night that you were serving Jessica at the bar, right?
That's my understanding, ma'am.
If you had seen Jessica acting that way, you might have cut her off. Isn't that a fact?
I might start to think about it. I certainly wouldn't have cut her off if I had just seen that, no. But I would have.
Okay, so, sir, so you would have started to think about cutting her off after watching what she was acting like in that video, right?
Well, yes, ma'am. I hate to sound like a broken record here, but if I saw somebody like that, it would make me a little concerned and I'd start to watch them more. I don't think the person in that video was obviously drunk. I just might start to think about it. Does that make sense?
Well, sir, that wasn't what I was asking you. I wasn't asking you if you thought that she was a little drunk. I was asking you about whether you were going to cut her off or not. My question is, if you saw her acting like that in the video, in person in front of you, you don't know if you would cut her off or not, right?
Exactly. That's what I said, ma'am. I would have to see. I would have to monitor her. I certainly wouldn't do it automatically. I don't know.
Thank you. Nothing further.
Redirect?
Yes, Your Honor.
Go ahead.
Permission to pull back up Exhibit 17, the receipt that was previously displayed?
Yes.
Mr. Mehta, you were just asked a lot about items on this receipt. I got to ask, did you actually see Ms. Marks and Ms. Levin as they drank these items?
I guess I might have been walking by, but not specifically each of those. I couldn't tell you who drank what, if that's what you're asking.
We can go ahead and take that down, Ms. Schaefer. Thank you. Sir, you were just asked about whether or not you saw signs of what they just called obvious intoxication. I got to ask, throughout the entirety of that night, did you think Ms. Marks was obviously intoxicated?
Absolutely not, ma'am. I watch for those things, and I watch all my customers for those things. If I had seen those signs, I would have acted a very different way than I did.
So, sir, did you see any of those signs that night?
Not a single one, not in Jessica, no, ma'am.
Thank you. No further questions, Your Honor.
There's no recross unless you need to impeach. So I assume no recross here?
No recross, Your Honor.
Okay.
And may he be excused, Your Honor?
Yes, thank you.
Thank you, Your Honor.
Okay,
With
understanding, I'm sorry, go ahead, counsel.
that defense rests, Your Honor.
Thank you. It's my understanding that the attorneys cannot make a motion for a recess, but bailiff, can we check in with our scoring judges to make sure nobody needs a moment before we move on to closing statements or closing arguments?
I don't need a break.
Okay, hearing no complaints, we'll move right on to closing arguments. Attorney Gaskins, please proceed whenever you're ready.
May it please the court. Sometimes when people drink, they need other people to help take care of them. Maybe it's getting them a glass of water. Maybe it's calling them an Uber or taking a drink from their hand. People need people. That's why bars and bartenders have a responsibility to look after their customers when their customers can't look out for themselves after drinking. On March 24th of 2019, the defendant failed Jessica Marks. She was only 19 years old. She never got to have another night out with her friends. She never got to finish college. She never got to say goodbye to her family. And it was the defendant who could have helped prevent that, but they didn't. The defendant ignored the obvious. That's why Jessica's mother sued the defendant for wrongful death. Now, as the plaintiff, we had a burden of proof today. We had to prove to you 4 elements are more likely than not to be true. If you could put those elements back up on the screen for us to take a look at. We already agreed with the first 2 elements, so I asked you to focus on the last 2. We had to prove to you that the defendant served alcohol to Jessica Marks when she was an obviously intoxicated minor. And last, we had to prove to you that the defendant serving Jessica Marks was a substantial factor in her death. Now, I do want to make something pretty clear, because the only way you get to the affirmative defense that Ms. Shepard has been talking about in her opening statement is if you agree that we met our burden on those last 2 elements. That's the only point where you consider whether Jessica is responsible for her own death and believe their victim blaming argument. But we met our burden. So we're going to talk about how we met our burden. And I'm going to ask you to focus on those same three things that I asked you to focus on in opening: the drinking, the defendant, and the driving. So let's take those one by one. The drinking. It's common sense, members of the jury. The more someone drinks, the more likely they are to be drunk and look drunk, and for people to tell that they are drunk. So let's talk about how much Jessica really had to drink that night, how much this bar was serving her. If you could put that receipt, that bar tab back up on the screen. She finished that bottle of wine. She had all of those White Claws. She had one of those beers and one of those shots. And you heard from Morgan Levin, not only that, she also had a mixed drink, a rum and Coke. That's not even on this receipt. Members of the jury, let's be conservative. That's at least, 5, 6 different drinks? Think about it. Use your common sense. Is it more likely than not that someone who had that many drinks in like a 2-hour time span is obviously intoxicated? Absolutely. That's how bodies work. That's how they process alcohol. And let's put that pre-admitted autopsy back up on the screen, because her blood alcohol content was 0.16 at the time that she died. And you know that that was enough for her to be obviously intoxicated. But look, we couldn't just prove to you that she had a lot to drink. We had to prove to you that she was impaired too. And that's where Morgan Levin comes in. Morgan Levin, she took the stand today, looked you in the eye, and told you exactly how all of those drinks were affecting her best friend. Bloodshot eyes, she was slurring her words, she almost fell. She was showing those signs. The defendant was the one who was ignoring them. And that brings me to my next point, how the defendant knew, but the defendant did nothing. Now, all day, the defense has been trying to convince you that there was no way to tell. A moment ago, the defendant told you over and over again, I couldn't see it, I didn't see anything, I didn't see anything. Members of the jury, be real with yourselves. Let's put that video back up on the screen for a moment.
Well, go big or go home.
This was the mood. This was the attitude. This was the vibe of how Jessica was acting that entire night in front of her friends, in front of the bartenders. Did they really expect you to believe that Jessica was just acting like this in one moment and then turned it off the next? That is absurd. And you know that the defendant knew about how she was acting because the defendant said it himself. We might need to cut this one off. But he didn't. And that's what makes this case so tragic. And that brings me to my last point, the driving. The defendant watched Jessica leave that bar and get into her car. So let's play devil's advocate for a moment. Let's say that Jessica actually looked totally fine. Could you put that map back up on the screen? She only made it 1,000 feet. Is it more likely than not that someone who was totally fine, seemingly totally fine, only made it a second down the road before they crashed? Or is it more likely that somebody who was obviously intoxicated couldn't make it? She was drunk. That's it, members of the jury. We proved our case. So I'm going to ask you to come to the only conclusion that you can, that the evidence supports and the law requires, find the defendant liable for wrongful death. Thank you.
Defense, whenever you're ready.
She carried the keys. And in the end, it did kill her. Members of the jury, from the glasses of wine she drank before she left her house to the shots she had just before she walked out that door, for Ms. Marks' decision after decision ended in tragedy. But it all started with those keys. Because she decided to drive to the bar that night. She decided to drink while those keys were still in her pocket, and she decided to drive home again. Members of the jury, the moment that she took out those keys after a night of drinking, she took the responsibility of her life into her own hands. And today, no one else can be held responsible for that decision. But today, the plaintiff told you to find that someone else is responsible. They told you to find that Sonny's bar is responsible for the death of Ms. Marks. They told you today that Sonny's bar ignored the obvious. Well, members of the jury, today you heard for yourself, you can't ignore what you don't see. What evidence did they present to meet their burden of a preponderance of the evidence? Not testimony of Ms. Marks telling people she was drunk. Not footage of Sonny Mehta next to Ms. Marks as she was acting drunk. Not an expert to tell you how alcohol could, should, would, did affect Ms. Marks that night. What did they present? One witness, a receipt, and a video. But even that, members of the jury, we can't rely on. So first, let's start by talking about the receipt they showed you. They showed you this receipt to tell you that she had so much to drink that night, members of the jury, so Sonny Mehta should have known. But let's be clear. What did he tell you? When I asked him questions at the end of this trial, he told you, looking at this receipt, he can't tell us who had what drink. He can't tell us who had how much of each drink, how it affected each individual person. That's not a reasonable basis of finding him liable. That's not proof. So now we turn to that video they showed you because members of the jury, let's be very clear. Today we have two people saying different things about what that video means. Ms. Gaskins just told you in her closing argument that the receipt alone doesn't tell us that they had too much to drink. They relied on Ms. Levin to tell you that Ms. Marks was too intoxicated. They relied on Ms. Levin to characterize that video for you, members of the jury. They're relying on you choosing to believe a he said, she said case where you decide that the person that night who was drunk is more believable. That's not proof by a preponderance of the evidence, members of the jury. That's not a reasonable ask for you. They haven't met their burden. They haven't proven their case. So let's talk about the affirmative defense. You see, today we've asked you to ask yourself if you believe that they did meet their burden, whether or not Ms. Marks's decisions were a substantial factor in causing her death. And today we have shown you by a preponderance of the evidence that they were. Members of the jury, I want to make it clear, it's not easy for us to get up here and ask you to find a girl who died at fault. It's not easy. But our job today is to look at the facts. So let's talk about the facts, because today you heard she carried the keys and it led her to make 3 careless decisions. Decision number 1, she chose to drive that night. Now, today we showed you a map. And on cross-examination of Ms. Levin, we made very clear where they started and where they ended. Today you heard that Ms. Marks, knowing she was going to go drink, chose to start in Brentwood and drive all of the way to Malibu. Members of the jury, that's a drive. That's a decision. Driving all that way with the intention of driving right back after having drinks is not reasonable care. Which leads us to decision number 2. Because today you heard that after making that drive, she did, in fact, drink. And members of the jury, I don't have to tell you about that because Ms. Gaskins just got up here and did. You heard that Ms. Marks made order after order that night. She chose to drink while the keys were still in her pocket. Which brings us to that last decision, the most tragic one. Because today you heard that even though Ms. Marks had other options, she chose to drive home again. Members of the jury, at the beginning of her closing argument, Ms. Gaskins told you that people need people, that Ms. Marks needed someone to call her an Uber that night. Well, we know that someone did. Ms. Levin took the stand today and tearfully told you that she begged Ms. Marks to come home in that Uber, that she would pay for it because she was concerned for her safety. But Ms. Marks had already made her choice. Those keys were heavy in her pocket. She took and she carried those keys all the way to her car and turned on the ignition and drove away. And we know what happened after. Members of the jury, it was Ms. Marks who decided to carry the keys. It was Ms. Marks' decision to drink after carrying these keys, and it was Ms. Marks' decision to use them. That's why we're asking you to find Sonny's Bar not liable for her death, because she carried the keys, and that's what killed her. Thank you.
Go ahead with rebuttal whenever you're ready.
She carried the keys. Members of the jury, Sonny's Bar carried the responsibility. Let's talk about that video one more time, because if you believe that Jessica Marks was intoxicated, obviously intoxicated in that video, we have proven our case. So let's talk about what the defendant thought about it. Because when the defendant watched that video, the defendant was the one who said, I could possibly have cut her off. I don't know if I would have. Even the defendant agreed that she looked obviously intoxicated in that video. So use your common sense and find the defendant liable for wrongful death. Thank you.
Thank you to both advocates. Now that we've finished the trial, we're going to have the judges complete your ballots and click submit. Everyone please stay on the call until everybody has submitted their ballots, and we'll do very, very brief comments and let you all go. Bailiff, can I ask you to help me figure out when everybody has finished submitting their ballots?
Yes, I'll get the okay from Justin and Phil, and then everyone can turn their screens back on and we'll do comments.
Thank you.